My name is Amáda Márquez Simula. I'm the mayor of Columbia Heights, and just want to thank you all so much for coming here on a weeknight, beautiful evening, to learn more about the rentals. We're covering today with Assistant Fire Chief Dan O'Brien. So thank you so much for coming, Dan. I also want to say thank you. We have two interpreters with us. Elizabeth in the back is interpreting Spanish and English. And Farah is here to interpret in Somali if we have any guests that speak Somali. So you may hear some whispering in parts of the room while people are translating, but we will be patient and pause if we need to make sure everyone gets to hear things. So for this evening, to give the expectations what the meeting will be, and is we're going to go over the property maintenance and rental licensing, and with a presentation with Dan. Then we're going to hear from some housing advocates, and then we're going to take questions that anyone may have. So what we're going to do is take all the questions, write them down. If we have time, we can answer some. Otherwise, we'll do an email and email all the answers out to everyone who's on the list. Some questions need research and we can't answer right away. And we definitely want to follow up. So if you haven't yet, we ask you to fill in the form at the front desk, and you can just turn that upside down and leave it there, and that way we have your email and we can get a hold of you. And we hope to have other meetings like this, just to be proactive for people who want to hear more information about what we have here for tenants' rights in the city. So thank you again for being here. I know that this can be a very stressful time for what people are going through. And we're here to help as best we can. So I'm going to hand the mic over to Dan. Well, you have a mic clipped in there, right? Okay. Okay. All right. Thank you.
Again, good evening. I just wanted a quick, Kevin, before you leave, Kevin, I just want to introduce this is Kevin Hansen, our city manager. We have a couple council members in the audience as well. We have Connie Buesgens and KT Jacobs. So like I say, they're good resources if you guys have additional questions or want to talk about stuff. And you two are again from, I'm sorry, one more time. Housing Justice Center. So they might be able to help with some of the legal stuff. We do have a speaker scheduled from Central Minnesota Legal Services. She's supposed to be here, Elizabeth. So if when she gets here, she's on our agenda. If she doesn't, you guys are going to be put on the spot a little bit and we'll do puppets or something. Yes. That's fine. No worries. Perfect.
Thank you, Dan, for the rest of the...
No worries. One of the other things that we can do with the questions, because there's going to be obviously there's not a lot of tenants that are not here this evening or not online. What we can do is we can when we take those questions, we'll write the answers. We can actually post them on the city webpage. I think we have some tenants resource information on there. We'll just put it in there, some question and answer stuff. Super simple for us to do. So if you look at the city's website under rental licensing and tenant resources, that's where we'll post the questions as well. So I will email you if you have an email address with them. We'll post them on there as well. So quickly this evening, I don't want to bore you to death with PowerPoint. So I'm going to just do a kind of a high level overview of what the property maintenance code is and rental licensing for the city of Columbia Heights and what it looks like. I'm gonna need a drink of water, sorry. So the entire purpose of a property maintenance code is kind of what you see there. It protects the character, stability of all the premises, which properties in the city. Basically protects life, safety, the general welfare of the public, and the health. And they are a set of minimum standards. So the entire property maintenance code is based on the International Property Maintenance Code, which is a model code that is out there, just like the building code, the fire code, gas code, that they're codes that an organization takes, amends to their needs, and adopts. So the city of Columbia Heights, property maintenance is usually adopted at the city level. Different versions of it. Columbia Heights is not unique in that we have a property maintenance code or that we license rental property. And then, of course, preserves the value of the land and the buildings in the thing. It applies, property maintenance applies to all buildings and land in the city, basically existing residential and non-residential structures. Once a property is built with the building code, it's turned over to the property maintenance code until something changes where they're going to make alterations to that building, then it has to conform to the building code. That makes sense? The city's role is property focused to enforce those bare minimum standards for code. Our job for the fire department is we do the inspections. We present the licenses and our results to the city council for consideration, denial, suspension, revocation, or approval for rental licensing. So only the city council can issue a license, and only they can take away or do anything with it. They're also the appeal board. So if somebody disagrees with the way that we're interpreting something in the code, they can bring it to the city council to discuss. They have to be the person that it's affecting directly, like the property owner. We're telling them that they have to fix a window a certain way and they disagree with that. They can come to us, they go to the city council and argue their case for that. Just a little bit of help here because we have a lot of, we take a lot of tenant complaints on properties. So I just want to make some clarifications on how we accept complaints and how we deal with complaints for the city. So you should always, when you're signing your lease and you're talking to your landlord, there's some way that they have you report your issues, broken this, broken that, whatever. So you should always work through that process first. Give them a reasonable length of time to fix that issue, to respond or fix the issue. So reasonable varies depending on really what's wrong. If it's the middle of winter and it's 40 below outside and you have no heat, I think 12 hours is probably more than reasonable for them to respond and do something about that. Now, they may not be able to get a part, but they can take measures that are approved to get you some temporary heat in the meantime, okay? Whereas maybe a cracked window or broken or peeling paint or something like that might be something that, okay, a month, maybe that's reasonable, So it really depends on what kind of violation. Does it affect the habitability of a property? Does it affect life safety? That sort of things. And for your benefit, document. Our lawyers in the room would agree with that. Photos, save your emails, take screenshots of your texts to them, make a call log, things like who you sent it to, what the issue was, the date and time you reported it, who responded, the date and time they responded, and then basically what was, what the resolution was or the issues that you presented them and how they got corrected or if they got corrected. So just some good things. They probably have more to say on that when they get to their piece. So I'll leave it to that. We do have a complaint line. There are business cards on the table over there. Please take one. It has our fire department inspection line on there. You can email a complaint to our email fireinspections@columbiaheightsmn.gov. Just include your name, a callback number or email, and then kind of what the complaint is. And of course, we'll get back to you as soon as we possibly can. The complaints they should fall within the scope of what the property maintenance is. So we can't affect how much you're being charged for rent. We can't affect things that are civil disputes. Like they walked in when I was in the shower or whatever to do something without notice or something. That's a civil dispute between the tenants. We're here for complaints about the property, that sort of thing. They should come from the tenant, person who's on the lease, or an occupant of the building. We tend not to accept complaints from anonymous people, for the simple fact is we need to know basically if it's from a tenant, are they under a lawful detainer? Are you under an eviction notice? Then it becomes a he said, she said, and we're getting involved in that, and between that, in that civil issue between the two. If it's the caveat to that is, if it's a life safety issue or habitability issue, we'll investigate it and take appropriate action there. Our rental licensing program, when a property is going to be licensed, consists of basically three pieces. They have an inspection, they fill out an application, they pay a fee. All the rest of that on there is minutia, but those are the three key pieces for licensing. And I can put this presentation online too if you want. So that's easy enough to do. But so new rental properties are inspected by the building official and then turned over to the fire department for ongoing licensing. And then we inspect on every other year basis currently. Every year they get an exterior and common area inspection if the building's big enough. And then on the other year, we do an exterior common area and interior of the unit inspection. Now they should be giving the tenants reasonable notice of the inspections, which they'll probably talk about, yes. And of course, tenants should allow them in to make repairs and things like that and work with them to do those types of things as well. Application, we don't license faceless corporations. We make them present a human being to us. So, and we do have contact information for your landlord. So if you don't have good contact information for your landlord, let us know, because everything that they give us, with the exception of a driver's license and like any financial information like a social security number or something like that, is available to the public. So, and we actually often get a lot of requests for landlord contact information. So we have the property owner information, we have the licensee information, and we have the property management information. Sometimes they're all the same person, sometimes they're three different entities. And then the fees. So revocation of a license. Why do we revocate? It's really one of the only effective tools that the city has to hold the landlord responsible. We can write them a citation for not fixing something. They can months later go to court, talk to a lawyer or talk to a judge. Judge might fine them some money, and then maybe they pay it, but maybe it doesn't get fixed. So holding them responsible, the financially piece for this is their income, is one of the only real true tools that we have to hold landlords responsible for maintaining their properties at that bare basic minimum level. And of course, affordable housing does not equate to unsafe housing. So people shouldn't be living in unsafe properties. Nobody wants that, right? It's totally against the goal of what we have as a city. So the reason we revoke a rental license is basically the first one, code noncompliance. The other two kind of fall under that because part of the code is that they have to submit their application. They have to pay all their outstanding fees. That's all parts of the code, but you'll notice that those are those three things that the same thing that they have to meet to get the license, right? So we designed our revocation process and recently redesigned it. So landlords, they've had notice. and they've had reasonable time, sometimes multiple chances to repair something, and they haven't done so, so we have to move to the next step, and that's present a license to revocation for revocation. Of course, it's not your guys' fault that the landlord failed to do what they're supposed to do. Sometimes they're too big, these huge corporations. Sometimes they just can't get it done. We tend to be reasonable. If they call us and when they work with us, they can give us some proof that they're working towards fixing it. Do whatever. We give extensions. We'll want to work with people to a certain degree. Again, if it's life safety, it needs to be taken care of in a timely fashion, that sort of stuff. So we want to hold the landlords responsible. We're not looking to punish tenants. And then failure, if we don't enforce the code, we're basically condoning potentially dangerous living situations, which we don't want to do. And we've extended our process out a little bit to give the tenants an opportunity to act, which means like coming here, meeting, talking to each other, contacting legal support, and potentially starting some other actions. This is a very complicated drawing, but that's kind of the whole process that we've mapped out. I'm not going to go through it just because we'll break it down a little bit. So when we do that initial inspection, we find a violation. We send a notice to the landlord. The landlord gets their compliance period, usually right around 30 days to correct it. If it's not corrected when we come back and there's no extensions or whatever happens to go on and it's not done, then that's when we take the next step and move forward in our process. And that's where we do the statement of cause and hold a notice of public hearing, and I'll go into that. We support the tenants when it comes to a revocation differently now than we did a year ago. We used to go inspection, next council meeting. When they fail it, the next council meeting that we can get them scheduled on is when we would do the revocation. Speaking with our experience through a mass revocation that we did recently, that time frame wasn't long enough for the tenants to get anything initiated. One of the things that they can potentially do is what's called the Tenants Remedies Action, and which I think she'll talk about, but it's nigh impossible to get that done in a shorter period of time. So we're kind of front loading some of this, so giving tenants a little more time, so when they get that letter that says consult legal, do that. Hopefully that stuff's starting to happen. We've added some additional pages with them. You guys should have gotten a letter, should have been a copy of all the other associated properties that are in the same boat that you are, and then some resources and a letter from us. So gives them time to do that. Now, typically, if it's a first revocation, it's the time frame is probably a little bit shorter. In our city, if any landlord, and actually most cities, if they lose a rental license, 2 rental licenses within 5 years, they're no longer eligible to hold an interest in another rental or license in our city for an additional 5, which means they can't manage one, their spouse can't manage one or own one or anything. If we can track them back to that, they're not allowed to hold a rental license in our city because they have failed twice. So when we do a 5-year revocation where they're going to lose 2 licenses, we're going to we try to extend that timeline out to give tenants more opportunity to meet with each other, contact, and take some action. You've probably recognized the 2 on the right. They look official. We give a copy of the outstanding violations to all the tenants for your guys' review. So when you go to your legal, that you have a copy of what the issues are. The one on the left is what do we send the landlord. Basically, it's very similar, but basically it's just letting them know that they're supposed to tell you as well that they're that there's a meeting for consideration of license, and that they could lose all their licenses based on that 5-year thing, plus another copy of thing. We do give them one last chance to correct those. So usually about a week and a half to 2 weeks before the council meeting, where they would hold the revocation, we do what's called a pre-council inspection, and that's their final inspection. So we usually try to schedule that within a day or two of when we have to submit our council documents for the following Monday. So it's usually the Wednesday before is the deadline. So it's usually that Monday or Tuesday we do the inspection. Documents get submitted Wednesday, and then the council meeting happens on the following Monday. There's on the page, that's where it says contact the Central Minnesota, Central Minnesota Legal Services, the Volunteer Lawyers Network, just a couple of resources right on the page for you there. So if they fail that pre-council, we submit the documents to the council and the public hearing is held. Tenants have a right to be heard at that meeting for or against the property owner. Okay, so you guys can show up at that meeting. You have a right to hear. This is kind of the landlord's day in court before the council that says, here are the facts in the case. Here's what you guys didn't do. They have a chance to stand there, argue their case to the council. Council hears both sides or one side, whoever's there. They elicit it, and then they decide what they're going to do with the license. And their options are do nothing. Give an extension. They could table it. They could revoke it. They can suspend the license, or they can add conditions. They can issue a conditional license. Should they choose to revoke the license, the next day we send out copies, a copy of the letter to left to the landlord to let him know if the rental license has been revoked. The property gets posted with the rental license notice, and then the tenants all get a copy of the notice that the property is saying. The verbiage here is a little different. It says, sorry, didn't see her pop in. The verbiage here is a little different. It actually used to say 45-day notice to vacate. Technically, it's the same, but it's rental license. It's just a notice that the rental license has been revoked. That in 45 days, the property technically becomes unlawful to occupy, which means that we can hold the landlord responsible for having somebody in the property. Hello? Again, talks about the legal piece. So approximately 45 days after that. So the timeline that we currently have for the properties that we're dealing with right now is the last pre-council inspections are done on the 27th and 28th of this month. Should they fail that, we would place them on the July 10th council meeting for consideration. If the council chooses to revoke, 45 days from that date would be, I believe, August 24th is when the properties would get posted as unlawful to occupy. So then the notice on the door changes, basically says it's unlawful to occupy. We send notice out, let the landlord know. Let the tenants know with another notice. And for your information, the city does not have the authority, nor do we want to, force or evict someone from their home, okay? So we don't have the authority to kick your door in and say, out on the street. We don't have the legal authority to evict people from their homes. We can only hold the landlord responsible for having somebody in there And optionally, we have the ability to hold the occupants of the building responsible for being there when they technically should not. Through a criminal citation, right? It's a misdemeanor offense each day. We can issue a new citation every day. There's discretion on issuing it. So I tell people it's a lot like a speeding ticket. A police officer can pull you over for speeding. They don't necessarily have to write you a speeding ticket. There's some discretion on how and when they write speeding tickets. But they will never, ever give up the right to issue a speeding ticket, right? Same thing here. We know that the tenants really aren't the issue in the property. So we're going to hold the landlord responsible, but we can't give up the right to issue a citation to the tenants if we had to, because there are situations where the tenants could potentially become a problem. So whatever, there's the city codes that we can write violations or citations for, basically allowing occupancy of, collecting rent from when you're don't have a license, removing one of those placards, refusing to comply with the code, giving false information on an application, letting the property be in violation, occupying the premises when it's not supposed to be licensed, and then occupying the posted property after its date, and then, oh, that's messing with the placard. So on in the letters that you got, there is a tenant resources thing, some good information there. I don't know if this link will work here. HUD has a great Minnesota page with some of the stuff that we have on here as well. The great, really good book, Landlords, Tenants, Rights and Responsibilities. If you don't have a copy, get a copy. You can actually get a physical copy. I think we might even have some at the fire department. I can't remember, but they're free. The state sends them out. Homeline, legal aid services, lots of tenant resources out there in the state of Minnesota. Encourage them know your rights, because you guys have a lot of rights as tenants. And then there's some HUD information, renters kits, home buyers kits, all kinds of really, really good information there. So highly encourage you to check some of that stuff out. Attorney General Keith Ellison, he's been working with his office in the past on one of the revocations that we've done of a very, very large corporate landlord that has purchased a lot of single family homes and did nothing. So, and then Minnesota court system has things. Just type, like say, any search engine, you type in tenant landlord rights, responsibilities, a lot of that information will come up, and a lot of it out there. Central Minnesota Legal Services here. There she is. Oh my, I have this. Give me a minute here. I have your presentation up here.
Do that because it couldn't help underneath the slides.
Ah.
Not everybody needs to see the scary places head when they're but it is helpful to make sure that I actually get you all.
I don't know why it's here, not here. I downloaded it, I ran it, it's here.
That looks like it.
No, that's my slide though.
Oh, that's your slide?
Yeah. I don't know how to.
Stop sharing. Share something else.
How do you get out of screen mode?
And then share again, maybe.
Ah, wait, it's here. There we go.
Okay. just, I can do it. There you go.
Showing up on the, so stop sharing. Go to.
So while we're sorting that out, I'm just going to add on one more thing that's not my about it, and I don't know how many materials we have over there. But another really great resource initiative that Dan gave you is the website is called lawhelpmn.org. Literally lawhelpmn.org. Okay, I love to tell folks, like, never, ever, ever get legal advice off the internet. Okay, and that's for a bunch of different reasons. There's a lot of bad advice out there. There's a lot of advice out there that is soda, but I can vouch for that website. That is maintained by all of the various. And so we update it every. Also, they've got a whole library with fact sheets and all kinds of legal topics.
Introduce yourself.
Oh yeah, sorry. I was gonna launch into that. Okay, sorry. So yeah, lawhelpmn.org. So it's a great website. It's a great way to, they've got a whole library worth of sort of like fact sheets about various legal topics, and then they also have, it's a good way to get referred to legal services, like an actual provider, or get other information too. So, all right. So hi, my name's Elizabeth Sauer, and I am a lawyer, and I work at Central Minnesota Legal Services. Wait, how am I doing this? Yeah. Okay. I work for Central Minnesota Legal Services. I don't know if anybody in this room has heard of us. We have been around for a long time, doing work in Anoka County. All right, thank you. Okay, so we've been doing work in Anoka County for, I don't know, 20 years. And I've only been around for 13 of those years. But those of you who have heard of Judicare of Anoka County in the past, unfortunately, Judicare no longer exists. But fear not, okay? We still exist, all right? And there are still legal services available to the citizens of Anoka County, and that's us. So we are a nonprofit law firm. All right, we provide legal representation, advice, and community education in 21 counties across central Minnesota to individuals who qualify for our services. Okay, I'm going to talk a little bit more about that. There's my very fancy map that I made of where our offices are. We're in Minneapolis, Anoka, City of Anoka, St. Cloud, and Wilmer. So. When I say we provide legal services to those who qualify, so great. I'm so glad to be able to be here today and talk to you all about tenant remedies. I'm going to try and keep it brief. There's a few different things that I just want to, from the outset, like we've got pretty strict requirements in terms of income and who qualifies for us financially. That we didn't come up with that. The people who give us the money to do what we do came up with that. That said, we'll talk about intake towards the end, but if you do want to reach us, there's a couple different ways to do that. And if you don't qualify for our services, we'll try and get you someplace that could at least be able to give you a little bit of help. We are the primary legal services provider that actually represents people in court for Anoka County. So I encourage folks to start with us, but maybe I'm a little bit biased. All right, and we do a whole bunch of things, right? We don't just do housing law, but housing is my area of expertise, and definitely a big part of what we do. So, there's also Mike in the back there, who I was sitting next to in the blue shirt. He's another attorney in our office as well. So just so you know. I'm going to throw out another disclaimer. I like to try and talk about this as much as I can, but I don't want to talk about it too much. We also have some restrictions on who we can serve in terms of immigration status. And I want to be clear and upfront about that so that if somebody calls us and is like, and told we can't represent them, so that you know. Now, that said, I also like to make it super clear, like, first of all, we don't care about anybody's immigration status, right? Again, this is something that's imposed upon us by our funders, and we have to follow the rules because we like doing the work that we are able to do. Also, please, so it's not like we're going to tell anybody if like an undocumented person contacts our office. Like, we actually can't. That would be a violation of our duties as attorneys, okay? The other thing is, don't assume that just because you're undocumented or not a citizen that you don't qualify for us. There's a lots of like exceptions to the rules. And for the most part, basically anybody who's either a citizen or a lawful permanent resident, we can represent. So those are not issues. And like I said, we do our very best to make the very most of all the exceptions to the rules that are available to us. Okay. So to get back into what landlords are required to do, okay? So you got the city, they do their thing, right? This is going to be a little bit about, what tenants can do and what your rights are. So there are 4 things that the law says that every landlord is required to do. They promise that the home is fit for the use intended, that it's in reasonable repair, and that it's in compliance with all of the health and safety codes. That would include the city code that gets enforced by Dan and his team. Okay, and then they have to make the home reasonably energy efficient. I include that because it's in the statute, but it's not the most useful provision. Okay. So when you're talking about lack of a rental license, okay, I think that can fall into a few of these different categories, right? Obviously, the landlord is not complying with the health and safety codes that apply to the property if they're not allowed to have a rental license. It's also arguably not fit for the use intended if, technically speaking, you're not legally allowed to live in a home if it doesn't have a rental license. So lack of a rental license is definitely an issue that comes up with repair issues, okay? There's also like actual repair issues, right? So my understanding is that, there are some homes out there that have repair issues, and that's part of what has led up to this potential for landlords losing their rental license, okay? And that can also be addressed, like the broken window, the lock that doesn't work, the leaky faucet, the pest infestation. Those are all also things that would maybe mean that the property has repair issues, that the landlord's not doing what they should be doing. Okay. So when you're looking at taking action in court, which is what we do as lawyers, okay, there's 3 different kinds of cases, basically, and they're all very similar in a lot of ways, but they're all distinct. So the first one is rent escrow actions. That's where you pay money into court. I'll get into that in a little bit. Tenant remedies actions and emergency tenant remedies actions. Okay, so a rent escrow can be filed. You have to have given your landlord written notice at least 14 days in advance, or there has to be an expired city, like a notice from a city saying to the landlord, you have to make all these repairs, and the deadline to make those repairs has to have passed. Either of those 2 things happens, you can go ahead and file the rent escrow action. Okay. The tenant in a rent escrow action pays any outstanding rent, any rent that they owe, into court. Now, I put a little star after that. It's an asterisk. It's not because, it's not like, A-Rod with his home runs. But it is because in some cases, right, if you don't have a rental license, arguably there isn't any rent that is due. So if there isn't any rent due, then you wouldn't have to post rent into court. Okay. The court takes care of serving the landlord in a rent escrow action, which can be a pretty nice thing, especially for tenants, maybe if you don't have an attorney representing you, right? Court hearing has to be held within 14 days from when you file the case, all right? And it's generally filed by individual tenants. A very similar action would be the tenant remedies action, TRAs we call them. All right, same kind of written notice as a rent escrow. All right, the statute doesn't say anything about rent posting. Sometimes it gets ordered anyway. The plaintiff actually has to serve the defendants, usually personally. Okay. But there's a lot of different people that can file a tenant remedies action, and by people I mean entities, right? So somebody who actually lives in a residential building where there's a violation, violation meaning any kind of repair issue, right? Violation of any of the stuff on that first page I talked about. A housing-related neighborhood organization with the written permission of somebody who lives in the building. Okay. Oh, I forgot that third one. Sorry. A housing, if the property is vacant, then a housing related neighborhood organization can just go ahead and file a TRA. You don't need permission from a resident. Obviously, it wouldn't be possible if it was vacant. All right. And then a state, county, or local department or authority charged with the enforcement of codes relating to health, housing, or building maintenance can also do TRAs. Emergency tenant remedies actions. As the name suggests, this is for emergencies, all right? And the statute spells out specifically what kinds of things count as emergencies, so loss of heat, loss of sanitary facilities, toilets, sewers, that kind of thing, loss of running water, loss of hot water, okay? Or loss of other essential services or facilities. So I have argued, would argue again, in the past that it's an essential service or facility to have a rental license for a home because you have to legally be able to live in a home in order, you know, that's pretty like basic part of being a landlord tenant. Not every judge has always agreed with me on that, or other colleagues of mine on that point. And I will actually note that the law just changed. So the legislature, like a couple weeks ago, passed a bill that actually really vastly improved a lot of protections for tenants in Minnesota. So beginning January 1st of next year, too late for anybody who's looking at this in the next couple of months, loss of a rental license will explicitly be included as a reason. It'll be explicitly an emergency. So, but not yet, so we still have to make arguments, okay? You only have to give 24 hours notice that you're going to file an emergency tenant remedies action, not like the 2 weeks like before. And then the court can grant the relief like right away. You can go in, you can get an order pronto. Hopefully that happens. I've had hit or miss luck with that in Anoka County. Okay. So here's kind of a summary of the things that a tenant can get if they file any one of those three types of cases, right? The court can order a landlord to make repairs, do whatever they need to make it, make the place up to standards. The court can refund past rent or future ongoing rent to the tenant, part or all of the monthly rent, okay? The court can order the tenant to make the repairs themselves and then let them deduct the costs of that from their rent. That's not something that Minnesota has the right to do in general. And I'm going to say for those two things about paying rent, again, this is assuming that rent is due. So it can get a little complicated, but that's okay. You can get an administrator appointed. So an administrator is an entity or a person, I guess, that can step in and basically act as the landlord. And they do that for the purpose of actually getting the repairs made that need to be done, getting everything kind of squared away. I worked with different administrators over the years. I know that there are a few that we've worked with in Hennepin County that would be willing to come to Columbia Heights, certainly, and there's a couple we've talked to in Anoka County as well. So that can be really helpful under certain circumstances. Okay, and then there's that last catch-all bit. Anything else that's fair and equitable, right? So that's sort of like create your own adventure. So things that I've had clients ask for that are not like listed specifically would be like, hey, you know what? I really just don't want to have to deal with this anymore. I want to move. Court, can you order that my lease is just over and I can move out and I'm not responsible for any future rent? I just don't have to deal with this anymore. That would be one example. Another example that I've discussed with folks in the past, it would be, you know, if you've got a landlord who's just failing, refusing, what have you, or just is not able to do their job as a landlord, maybe the court needs to order them to sell the property to somebody who can be the landlord, and, you know, do what they need to do in order to keep the property up to snuff. You have any questions? I guess we can save questions for the end, huh? Okay. Okay, so it's my job to like tell people like all the worst things that could happen, not because I think they're going to happen, but just so that you can be prepared for them and aware of them if you know about it, right? So things that a landlord could do to maybe get one of these cases dismissed if they show that like the problems don't actually exist. It's usually pretty hard to do, especially when you have like an independent third party, like a housing inspector coming in and saying, no, these problems actually exist. Okay, if the repair problems were caused by the willful, malicious, negligent, or irresponsible conduct of the tenant or somebody under the tenant's control. So, you know, don't set your house on fire. You know, don't have a campfire in your living room. Things like that. And just because the landlord raises these things doesn't mean that they can prove them, right? All this stuff would have to be, you know, presented in terms of facts in the court. Okay, and then the other defense that they would have is that the tenants, and this is what I really like to let tenants know about, if the tenants unreasonably refused entry, which kept the landlord from actually making repairs. Okay, now this can be a really tricky thing because tenants do have a right to privacy. And this law says, a lot of people think that the law says that the landlord has to give 24 hours notice before entering. That's not actually true. The law says reasonable notice. It's one of my missions in life to make sure everybody knows that. 24 hours notice is usually reasonable. But, you know, if there's like water flowing from underneath your front door, no notice is probably reasonable. In that case, a landlord has to leave a note saying that they were there and why they were there. You know, and in other cases, you know, if you're scheduling a repair person to come in, you know, 2-3 weeks out, more than 24 hours notice is probably reasonable. Okay. So what happens when a landlord doesn't or arguably doesn't give reasonable notice? That's where things get really tricky. So I would just generally advise tenants, like, err on the side of letting your landlord in if you possibly can. Document everything, you know, the notice that they gave you or didn't give you, because there's also penalties for violating your privacy, but especially when you're dealing with loss of a rental license, that kind of thing. I mean, it's just helpful to get the repairs done, even if the landlord is not doing what they're supposed to be doing in terms of notice. Okay, in a rent escrow action, the landlord can counterclaim. That's a lawyer word, right? Basically say, nope, in fact, I want the tenant to be evicted because they haven't posted all of the rent that they owe. Again, that would be pretty difficult if there's no rent due because there isn't a rental license. I hear this a lot from tenants. I don't want to make my landlord angry. I don't want to rock the boat. I don't want to get evicted. Okay, there are protections from retaliation for tenants enforcing their rights. Okay, the law actually presumes that if a tenant makes a complaint or tries to enforce their rights, any notice to vacate that they get within 90 days of that is presumed to be retaliatory. That means that the landlord would actually have to prove that they had a good reason that arose at the same time that has nothing to do with the tenant enforcing their rights as a tenant in order to enforce that. Okay, There's also protections against, unreasonable rent increases that are retaliatory, decreases in services, other things like that. Rules changes. Okay, so what happens if your home doesn't have a rental license? Okay, so really important thing to note that does not end the tenancy. So a landlord can't just go to court and evict you because they don't have a rental license. Like, that just doesn't make sense, right? So they still have an obligation to provide you the housing that they agreed to provide under the lease contract. By the way, leases can be oral or written. They don't have to be in writing. So folks will often say to me, "Oh, I don't have a lease." Yeah, you do. You have an oral lease. Even if you don't have something in writing, you've been paying rent, your landlord's been taking it, you've got a lease. Okay. So, and I've said this a few times already, although I should probably put a caveat on it, right? I will believe with my dying breath, and also it is really good legal advice that tenants do not owe rent for time periods when there's no rental license for their home. Okay. There's some really, really old case law. We're talking like 1800s, like early 1900s case law from the Minnesota courts that say that very clearly and emphatically. There's some more recent cases that have been discussed by the Minnesota Court of Appeals, which aren't technically not precedential, but like they all say the same thing, and they all say, yeah, you really can't do that. So I think it's a pretty good argument. Now, the other thing is that, first of all, I can never 100% guarantee what happens in court ever. Not with my clients that I'm working with on an individual basis, and definitely not in like just a broad overall, without any of the details of a specific case. But that's a pretty good, it's a good argument. I would argue that to the highest court in the land. I would love to someday. I would really love to get the opportunity to do that. Okay. The other thing, though, is to plan ahead and realize that if you're counting on not having to pay rent because your landlord doesn't have a rental license, that can change pretty quickly if they get the rental license back or an administrator is appointed, something like that. So, yeah, it's good to plan ahead and be ready for those things. All right, and the other question then is what should you all do? I can't give you specific legal advice today. I'm just here to make an overall presentation. Anybody who wants specific legal advice should contact our intake line. But here's the key, don't do nothing. All right, just kind of like waiting it out is just never a good idea. I would really recommend that anybody who actually has repair issues in their home, especially, anybody who's got repair issues in their home, but especially those repair issues have been cited by the city of Columbia Heights, act now, okay? There's a good chance that you could file a court case right now. And frankly, you might even be able to force your landlord to make those necessary repairs and avoid the loss of the rental license at all, maybe both for yourself and for the other tenants in your, who rent from your landlord, okay? Right? Get legal advice. Please get legal advice. I love talking to folks about housing law. I love helping folks with housing law. Mike does too, and as do the other attorneys in our office. Okay, and if we can't talk to you, Homeline is another option. The Volunteer Lawyers Network is another option. Now they won't be able to represent folks in court, but they can give really good legal advice, even if you just are not qualified in any way for us, okay? And then the last thing is to stay in touch with your neighbors. Now, I can't, because again, of the type of funding that we get, I can't do any organizing, all right? And I know that there are some folks who have done some organizing. There's major tenant organizing that's been happening in the city of Minneapolis over the past 5+ years. And some of that has spilled over a little bit into Columbia Heights in the past as necessary. I am not aware of any ongoing organizations that do organizing specifically, but would love to hear if I'm wrong about that, and would love to coordinate with anybody, talk to anybody who is doing that kind of work. The other thing I'm not aware of is any neighborhood housing-related neighborhood organizations that could serve as a plaintiff in a tenant remedies action, which we're mostly talking about single-family homes here. Yeah? Okay, all right. Tenant remedies actions, like with a possible like single plaintiff, are particularly helpful for multi-unit properties. So like a larger apartment building. If anybody knows anybody who's interested in doing that kind of thing, give me a call. Let me know. I would love to maybe connect those kinds of folks with some folks who could maybe help out with that, making that happen. That would be really great. Okay. Also when it comes to organizing, we love working with organizers where we can. Again, as I mentioned earlier, I'm a lawyer, right? I help people enforce their rights by going to court, okay? Or, just otherwise using the law to enforce their rights, right? Organizers can have a bit of a broader scope. And in my experience, love to sort of shoot for the moon in terms of okay, how can we really change things for the better and in big picture here? So we each have our roles to play. But yeah, please let me know if anybody is doing that kind of work or is interested in that kind of work. Okay, all right, that's our logo. We got somebody to make fancy logos for us, so we have to use it. So that main line there, the 651-332-8151, would be probably the best number to call if you are a Anoka County resident and looking for help with a legal case in the near future. I also include the statewide referral line there. That is a line that will reach all, I actually don't even know how it works. I think it magically sorts people by their area code, but basically it'll get you to a legal services provider in the state of Minnesota, whether that's, other organizations like ours, Southern Minnesota Regional Legal Services serves like the southern part of the county, of the state, that kind of thing, but can also get referrals to places like Homeline or VLN or others. So, okay. And I would be happy to take questions or talk to folks afterwards, just keeping in mind that I can't give specific legal advice.
Yeah. Hi, I did not create a presentation, so please let me know if you need me to repeat something if you're taking notes or to slow down. I'm Ivory Taylor. I am Associate Director with Housing Justice Center. These are a couple of my colleagues. This is Emma. She's a tenant organizer, and Abby is one of our litigators. And so, yeah, I just wanted to kind of talk about some of the things Elizabeth touched on. There are organizations, two places that do statewide organizing, that is Housing Justice Center and Homeline. I did work at Homeline for 4 years, and so my role there was organizing director. So Homeline does tenant organizing. Both of our organizations, we have limited capacity for it. So at certain times, depending on what's going on, we may or may not have the capacity to come organize with tenants, depending on if we have current things, if we don't have a lot of organizers at the time. So that's just something to keep in mind when you reach out to places that advertise that they do tenant organizers. There's like 5 of us, honestly. There's like very few tenant organizers in Minnesota. So we do the best we can, but we also prioritize campaigns. If we see there's going to be mass displacement, that's likely something we're going to lean towards intervening in. And so one of the things with organizing is that you can often organize together to get relief from things that there might not be a legal hook to. And so it might be bringing media coverage to the issue, which brings maybe bad publicity to a large corporate landlord who has a lot of properties and doesn't want that publicity, right? That gets lawmakers involved who can put pressure on landlords. So there's a lot of ways going outside of the legal system by doing organizing that you can potentially get some of your issues solved if there's not necessarily a good legal hook for it. One thing I would say is that at Housing Justice Center, we work at the intersection of law and organizing. So we do work where we bring our organizing campaigns and turn them into legal cases where necessary. So we do not do individual representation. We are not the place to call if you need individual legal advice. We don't offer that. That is Homeline, that is the VLA and the SMERLs. But if you're interested in organizing, if there's like a potential, we would potentially help support a tenant remedies action, something like that. We do look at wide scale systems change cases. So that could be, we're going to represent this property and potentially change case law for the better for all Minnesotans, as well as get relief for those tenants. That's substantive and based on what they want. We don't ever base case outcomes on what we think is the best outcome. We base it on what tenants want. So, if there might be potential, we could get more money, but the case would take 6 years, right? And so often tenants will be like, no, this is what I want, this is when I want it, and we go into settlement instead. And so that's kind of how our model is to focus on community direction in our cases when we're representing larger groups of tenants. So yeah, I think I can wrap up with that. But just want to say that we do exist. We're a statewide org. We serve all over. We have expertise in all types of different housing. And we work closely with a lot of partners, including legal aids, Homeline, like we're really connected to that ecosystem as well. And then we offer tenant rights trainings too, again, based on the capacity that we have at the time to be able to do that. So yeah, thanks. We do, it's hjcmn.org. And yeah, if you do call, we have an intake line. If you do call, you may get referred to Homeline if like the intake person is like, hey, this is like an individual thing, I'm gonna refer you over here. Or they might be able to like tell you about your rights or something. But we do take calls if you're like, our whole building has this going on, our building's going for sale, we're afraid we're gonna lose our housing subsidy. Those are things that we care about and we would look into. Yep.
Well, thank you. Thanks, Ivory and Emma, for being able to speak just so last minute, but figured since you were here, might as well chime in. So as of right now, we're going to add the PowerPoints to our city's website under our tenant pages, and then we can also have extra links on there so we have more resources. So city staff know how to direct people and also so people can find the resources themselves. And I just want to say, so thank you for your presentation and thank you, Chief.